What is an exclusion clause? And when will an exclusion clause be valid? Hi, and welcome back to another episode of the series The Case Files. In today's episode, we'll look at the case of Olley versus Marlborough Court Hotel, which is an important judgment in contract law which tries to answer the question, when is an exclusion clause valid? Let's get started. Olley versus Marlborough Court Hotel is an English case on contract law, more specifically on the validity of exclusion clauses in a contract. So what exactly is an exclusion clause? An exclusion clause is a term in a contract which tries to exclude or restrict the liability of one of the parties to the contract. It's a clause which excludes or restricts the liability of a person for non-performance of their obligations under the contract. A good example of the exclusion clause is the clause which says that a parking lot owner will not take responsibility for any damage caused to your car inside the parking lot. Now, since an exclusion clause allows a party to restrict their liability, the courts have looked at these clauses quite negatively and interpreted them narrowly. The case of Olley versus Marlborough Court Hotel highlights the importance of incorporation and timing of exclusion clauses in a contract. In this case, Mrs. Olley was staying at the Marlborough Court Hotel in London. One day, she left her room key in a rack behind the reception as she had been told, and when she returned, the key was missing and her fur coat, which was in her room, was stolen. She asked for the hotel to reimburse her for the cost of her fur coat. The hotel refused, relying on an exclusion clause which was placed behind the door in her room, which stated that the proprietors will not hold themselves responsible for articles lost or stolen unless handed to the manageress for safe custody. The courts had to decide whether this exclusion clause pasted to the back of the door in the room that she was staying at was a term in the contract between her and the hotel. The Court of Appeal held in favor of the claimant, Mrs. Olley. The courts held that the exclusion clause was not properly incorporated into the contract which was entered into between Mrs. Olley and the hotel at the reception. The notice seeking to exclude liability was not visible to the guest until the contract had been formed and she had entered into her room. The courts held that people who rely on a contract to exempt themselves from their common law liability must prove that contract strictly. Not only must the terms of the contract be clearly proved, but also the intention to create legal relations, the intention to be legally bound, must also be clearly proved. The courts went on to say that the best way to prove intention to create legal relations is by a written document signed by the party to be bound. Another way would be by handing over a written notice specifying the terms at the time of the contract and making it clear that those terms were part of the contract. The courts also said that a prominent public notice, which is plain to see when the contract is entered into, or an express oral stipulation would also satisfy the requirement. The court held that nothing short of one of these three ways will suffice. So what the courts were trying to say is that a person trying to rely on an exclusion clause has an obligation to make it clear to the other party that this exclusion clause is a part of the contract at the time of entering into the contract. Notifying them of this exclusion clause after the contract has been entered into will not be sufficient. The hotel in this case failed to notify Mrs. Olley of this exclusion clause before the contract was entered into. In fact, she only found out about this exclusion clause once she had entered into the contract and gone into her room and seen the back of her door. Therefore, the exclusion clause is not valid and therefore cannot be relied on. So the case of Olley versus Marlborough Court Hotel has significant implications because it clarifies when an exclusion clause forms a valid part of a contract. It stands to the proposition that representations made by one party after the contract has been entered into does not form a term in the contract. This means exclusion clauses need to be clear and conspicuous at the time of entering into the contract for it to be effective. This is why exclusion clauses are usually found at the entrances to places like parking lots and theme parks. Because in order to form part of the contract, it must be made known to the customer before the ticket is purchased and the contract is entered into. The case also helps to stop exclusion clauses from being used unfairly and surreptitiously by businesses to exclude the liability of their customers. And that's a quick look at the case of Olley versus Marlborough Court Hotel decided in 1949, which still forms a very important part of contract law. Anyway, that's it for this episode of the Case Files. Check out other episodes of this series by clicking on the link on the screen. I'll see you in another episode. Take care. Bye.